Hi everyone, welcome to today's webinar. We'll just wait for a couple more minutes just to let everyone jump on board. So we'll be with you in just a couple of minutes. Okay, thanks everyone. Welcome to today's webinar. My name is Simon Obee. I'm the Principal Lawyer at EI Legal, and I'm here today with my colleague Aahana Lakhia. Hi Aahana.
Hi Simon, thanks for joining us everyone.
And Aahana and I are actually sat in the same room, but appropriately social distance, so we're on different screens. I'm not sure if I put my hand across where I sit. There you go. And so first of all, a warm welcome to everyone. Apologies on behalf of Ben Thompson. Ben is the founder and CEO of Employment Hero. He was due to be with us today, but was unable to attend. So Aahana's stepped in to join me at the last minute. So thanks to Aahana. So yeah, today we're going to be talking about wage theft, and in particular the Wage Theft Act, which is a new piece of legislation that has just been passed in Victoria. So we'll talk about who that applies to in terms of which employers and which employees. We'll talk about what it covers, what are the obligations and the offences that are created by this new bit of legislation. We'll talk about the penalties, what employers face if they fall foul of the legislation. We'll talk about the Wage Inspectorate Victoria, which is a new regulatory body that is set up under the Act. And then we'll talk about how this legislation interacts with the existing legislation that deals with underpayments, principally in the Fair Work Act. So, and then after that, we'll finish off by talking about some tips for employers to stay compliant and to minimise risk. So even if you're not an employer in Victoria and you don't have employees in Victoria, do stick around, because the second section of the webinar will really be talking about the obligations that apply to all employers, regardless of where they're based, and tips which are going to be relevant to all employers, no matter where you are in Australia. And then we'll finish off by getting through as many questions as we can. So do use the Q&A or chat features to ask any questions that you would like, and we'll try and get through as many as we can, and we'll wrap things up by 3 o'clock. Obviously, anything we sort of talk about today is general in its nature, and if you do need advice on your individual situation, please do seek professional advice. We'd be delighted to hear from you at EI Legal if you do need some assistance. Okay, so before we jump into the detail of the Wage Theft Act, I guess just to give it some context, I suppose when I think of wage theft, that actual term, that sort of terminology, wage theft, we only really started to hear about that in the last sort of couple of years, where there were some really big kind of high profile, I suppose, cases of large numbers of employees being underpaid. There were several kind of high profile restaurant chains, supermarkets, household named businesses that were underpaying staff. And we started hearing, this term wage theft. And it was, at that time where the Victorian government sort of took the stance that the existing powers under the Fair Work Act, which are quite extensive and do already provide for employers to be faced with some really significant financial penalties for underpaying staff. Those provisions weren't doing their job. They weren't providing a sufficient enough deterrent to make sure that employers weren't underpaying staff. So they introduced this new piece of legislation, which was just passed by the Victorian Parliament in the last couple of weeks. You know, this kind of wage theft thing was a really sort of the big topic, I guess, of last year until COVID came along, and that obviously changed the focus of what people are talking about in employment law. But you know, in the background, this legislation has been going through Parliament. It's now been passed, and I suppose, yeah, the purpose of it was to make underpayments, make there be a bigger deterrent for underpaying staff by imposing a criminal offence in Victoria on businesses who underpay staff and do kind of related wrongdoing. You know, the consequence of breaching the Wage Theft Act is that there can be criminal penalties imposed. And I suppose if you wanted to sum up what this act does in a sentence and what it changes is, prior to this act, employers could be subject to financial penalties. Now there is the possibility of employers being faced with up to 10 years in prison for dishonestly underpaying staff. So that is a big change. It's making a criminal offence out of you know, an employment underpayment kind of type scenario. So that's the importance of the legislation, I guess, in a nutshell. It's due to come into force on the 1st of July 2021, if not before. Yeah, let's just kind of jump into the detail and let's sort of talk about what the new legislation does and who it applies to. So I guess the first question is, yeah, who it applies to, which businesses and employees need to be thinking about this, and who it applies to is employees in Victoria, employees based in Victoria. So the question isn't so much where the employer is based. If you're an employer in New South Wales but you have employees in Victoria, then this act applies to you. So it is where the employees are based, which is the important question. There's some complicated provisions in the Act about how it applies to overseas businesses with kind of links to Victoria, but for the most of the time, what you need to be considering is, do you have employees based in Victoria? If you do, then you need to be aware of your obligations under the Act. So I'll hand over to Aahana to talk a bit about the obligations under the Act and the kind of offences it creates.
Thanks, Simon. Okay, so what are the offences under the Wage Theft Act? The primary offence, as Simon mentioned, is that an employer must not dishonestly either withhold the whole or part of an employee entitlement, which is owed to the employee, or authorise or permit someone else to withhold whole or part of an employee entitlement. And the definition of withholding is quite broad under the Act. It's intended to capture a whole range of circumstances, including not only sort of withholding and not paying someone and failing to pay an employee entitlement, but also making an unlawful deduction from the payment, or imposing a fee or charge to an employee and requiring the payment of an amount from an employee to the employer. So it's quite a broad definition of what withholding means. There's examples of conduct which constitute withholding under the Act, and they're actually quite useful. And some of those are, for example, an employee who's required to pay back a portion of their wages to the employer, usually referred to as cashback. An employer who refuses to pay annual leave to an employee in circumstances where an employee has made a reasonable request to take annual leave in accordance with the terms of their contract or policy that the employer has. An employer who only pays an employee for their ordinary hours of work. So they pay them a base rate, but they refuse to pay them overtime penalties. And quite importantly, it also provides an example where an employer engages someone as an independent contractor when in fact that person should be an employee. So they're misrepresenting an employment relationship in order to avoid paying employee entitlements. So that can also constitute withholding if they do it dishonestly. The other main, I guess, aspect of it is what an employee entitlement is. Once again, it's quite a broad definition under the Act, and it includes any entitlements owed to the employee under the Fair Work Act, under a modern award, an enterprise agreement, and also any entitlements under a contract of employment. So it can include things such as wages, salaries, allowances, overtime penalties, and it can also include entitlements to annual leave, long service leave, an entitlement to take a meal break, and also to superannuation. So if an employer is intentionally withholding any of those things, it can be an offence under the Act. The second offence, like I mentioned before, is where they also authorise or permit someone else to withhold an employee entitlement. And there's a couple of examples of what that means, what authorising someone else. One obviously would be where they provide, I guess, a direct direction to someone else to withhold someone's pay, or if it's like a large body corporate where a board of directors has decided or given authorisation to someone to deduct or withhold someone's employee entitlement. Or, and this is quite an important, I guess, point, is also where there's just a corporate culture within the organisation where they encourage or tolerate this sort of conduct where certain entitlements aren't paid out or they're withheld. And corporate culture can mean anything. It can include like an internal policy. So say, for example, you have a retail shop where it's common practice within the shop where employees aren't paid outside of their rostered hours. And if sort of the employer just encourages that sort of behaviour and tolerates it, that can come within the, I guess, definition of authorising or permitting someone else to withhold entitlements. Another example is, say, for example, a restaurant where a manager asks certain employees if they, for example, drop food or break a glass, they deduct from their wages every time they break something. That can also, if that sort of behaviour is tolerated and the employer is not doing anything about it, that can come within the definition of authorising or permitting another person to withhold an employee entitlement.
Yeah, thanks, Aahana. I mean, it's interesting, isn't it? What struck me about all those things is really how broad the Act is and what it covers. Like when we talk about wage theft, we ordinarily think about just kind of like an underpayment of wages, but it's clear that it kind of goes, it covers everything really. I mean, prior to this, if you had issues with an underpayment of super, an underpayment of long service leave, and an underpayment of wages, you'd probably have to go to the ATO about superannuation. Long service leave is a state-based entitlement, so there would be a kind of state court you'd need to go to for that, and then wages would be covered by the Fair Work Act. So previously it was sort of harder for an employee to deal with all those things together. It's clear that the new government body that is going to be administering this Act, they're going to have responsibility for all of those things, which I suppose is one important thing to know. The other thing that struck me as you were talking is the we can all understand wage theft occurring, I suppose, where an employer says, you know, to his payroll or his or her payroll officer, you know, I want you to underpay Johnny by $10 an hour because, you know, that's the only way I can afford to keep going. But it's clear that the Act covers a sort of a lot broader circumstances than that, just where, as you said, there's this culture of underpayment, allowing people to work extra hours, but not paying them perhaps when they come in for training or something like that. And it's sort of, it catches that sort of conduct as well, which is obviously like a lot broader than you might think. The other offence that is created under the Act is to do with records and record keeping, and it also creates an offence for falsifying records and failing to keep records. And the Act provides a couple of examples of how that might arise, which I'll try and just dig out. So an example of falsification of an employee entitlement record is where an officer asks payroll staff to alter the number of hours an employee has worked on their timesheet with a view to dishonestly obtaining a financial advantage. And another example is an employer alters an employee's payslip to provide a misleading rate of pay with a view to dishonestly obtaining a financial advantage. And then there is some examples of offences relating to failure to keep records, which are where the employer pays the employee for work performed but does not keep a record of the hours of work performed or the amount paid to the employee. And another example is an employer paying the employee for set shift hours and recording these hours, but not recording the additional hours that the employee works as overtime. So I think it's important to realise there's this whole kind of underpayment, withholding of employee entitlement payments as one kind of bucket of offences, but there's also this second bucket of offences which relate to not having proper records or not keeping records at all. Both of those types of offences require the employer to have acted dishonestly, and I suppose that is because the consequences of breaching this Act are so severe. We'll come on to exactly what those consequences are, but as I mentioned at the start, a potential penalty an employer can face is imprisonment. So the Act is clear to point out that an honest mistake isn't going to be a breach of the Act, which is going to lead to jail term. There needs to be this element of dishonesty on the part of the employer, and that makes sense, I guess, for a criminal offence, which is usually associated with dishonesty. But what is interesting in the Act is how dishonesty is defined. And what it says is dishonest means dishonest to the standards of a reasonable person. This is to be an objective assessment and displaces the subjective assessment of the accused's state of mind. It is also intended that the assessment of dishonesty go beyond intentionally dishonest conduct and for recklessness to be captured as part of a reasonable person's understanding of dishonesty. So that's kind of quite a lot of jargon, but in essence, what they are saying is it won't be necessary for the court to find that the employer was actually deliberately underpaying someone. The state of the employer's mind won't be relevant. It is what a reasonable person would consider would be dishonest. So it's a lower test in that sense. If a reasonable person would consider that the conduct of this employer was dishonest, that will be sufficient. The other thing it makes clear is recklessness will also be will meet the threshold for an offence under the Act. So that means if you're an employer and you kind of willfully sort of put your head in the sand to avoid knowledge of an underpayment, that is probably going to be sufficient for an offence as well. So it won't be possible for an employer to, if they're getting sort of advice from their payroll staff or whatever about, we have concern about whether this salary is sufficient to meet this employee's hours or whatever, it won't be sufficient for the employer to say, "Look, don't tell me about that," or, to not open the email and to sort of turn their head away from that, so that they don't have knowledge of the actual offence. So that kind of recklessness, but without kind of knowledge of the actual issue, that isn't going to be a defence. The legislation does make clear that there is a due diligence defence. So if you've done everything you can as an employer to pay an employee correctly, but through an honest mistake, an underpayment has occurred, an offence under this Act won't have occurred. So due diligence basically means doing all you can to try and get it right. A classic example of due diligence would be engaging a professional payroll person or legal advisor or HR advisor to give you advice on what you should be paying staff. If you relied on that advice, it's unlikely that you will have committed an offence under this Act. So I think that's all I was going to say about dishonesty and recklessness, unless you've got anything on that, Aahana. If not, should we talk about what the penalties are?
Yeah, sure, Simon. All right. So the key question, I guess, on everyone's mind is, what are the penalties if you're found in breach of the Act and you're found to have engaged in these offences? What can you be liable for? So in the case of a body corporate, a company, it's up to 6,000 penalty units, which is approximately $991,000. So it's quite a significant financial penalty, and individuals are subject to a maximum of 10 years in prison. Again, quite a sort of significant penalty for sort of withholding employee entitlements or falsifying employee records. In terms of who an individual is who'd be liable to go to prison for up to 10 years, the Act defines, it says, makes reference to an officer of a company. So an officer can be anyone like a director or a company secretary, a shareholder, but it can also, in entities, be someone who actually makes decisions and has the right to make decisions that can affect the whole or a substantial part of the entity. So it can be someone like in a senior executive position, like a CEO or a COO, a financial manager or accountant, or even HR, senior HR manager. So it can include senior people and officers within an organisation. So they can also be liable if they're found to have engaged in this dishonest conduct, and they could face prison time of up to 10 years, which is quite significant, which is, I guess, like Simon was saying, why the element of dishonesty is key in this legislation.
Yeah, absolutely. And so, that definition of an officer, it's an important one. I think you're right. It could apply to directors and shareholders, but as long as they had an ability to make decisions about the company which affect a large portion of it. So kind of, if all you are is a shareholder in a business but don't have any kind of influence over the company's direction, I think you're going to be okay. But certainly, senior employees are going to be potentially caught. So I suppose lastly, on the Act itself, it's probably worth mentioning that the Act creates what's called the Wage Inspectorate Victoria, which is a government body which is going to be responsible for kind of regulating wage theft in Victoria. And the Act gives this body, some very wide powers of, being able to inspect workplaces, seize documents and evidence and that sort of thing, and also gives them the power to prosecute, so to make court applications to for employers to be penalised. Obviously, it'll be a court that ultimately decides on what penalty to bring. So, you know, the exact details of how the Wage Inspectorate Victoria is going to work is still to come, but one would anticipate that they are going to be open for employees to make complaints to them, which they will then investigate and prosecute if they think there is an issue there. I expect there's also going to be you know, random audits, etc. So in a sense, it will operate quite similarly to the Fair Work Ombudsman, which is the kind of federal regulator responsible for sort of enforcing the Fair Work Act. And you know, one of the kind of criticisms or questions about this new new legislation and the new body is how the two are going to interact. And I saw a question came up at the start about, can employers now be subject to inspection and prosecution by both the state body, the Wage Inspectorate Victoria, and the federal body, the Fair Work Ombudsman? And the answer is yes. How that is all going to link together practically is still kind of up in the air, I guess. But yeah, that is kind of one of the criticisms of this new system, and I have seen talk about challenges to the Act itself for being unconstitutional, for having these two kind of overlapping functions. So we're just going to have to see how that plays out. Which kind of brings me on to the next area that we were going to talk about, which is the interaction between the Fair Work Act obligations and the new obligations under the Wage Theft Bill. And you know, I said at the start that this new legislation is something that only applies to employees in Victoria. So if you don't have employees in Victoria, do you have to worry about wage theft? Do you have to worry about underpayments? How does that all kind of work together? And I suppose it's really important to understand that the businesses everywhere in Australia are subject to the Fair Work Act, save to, you know, for a few sort of exemptions for certain businesses in WA and business and sort of organisations in the public sector, you know, in the government sector. But the Fair Work Act generally applies to every employer, and there are provisions under that which mean if an employee is underpaid, an employer can be in serious trouble. Individuals involved in offences, so directors, senior employees who'd be involved in underpayment, can be fined up to $12,600 per contravention, and businesses can be fined up to $63,000 per contravention. There are also offences under the Fair Work Act for underpayments, which make those penalties increase by up to 10 times where there is a serious contravention of the Act. A serious contravention is defined as one where the person or business knew that they were contravening the Act, so, you know, not an honest mistake, and where the contravention was part of a systematic pattern of conduct affecting one or more people. So, you know, getting it wrong for one employee wouldn't be sufficient, but where it's part of a systematic underpayment issue, that could be deemed to be a serious offence. And in those cases, the fines are $126,000 for individuals involved in that, and $630,000 for employers involved in the contravention, so businesses. It's also important to note that the Fair Work Act has provisions that target franchisors and holding companies if they're taken to know or that they should have known of underpayments or other contraventions that are happening within their franchise network or within their subsidiary companies. Those penalties that I've talked about are also applicable. And I suppose the difference between the Wage Theft Act and offences under the Fair Work Act is this requirement of dishonesty. So if you haven't dishonestly underpaid someone, or either deliberately done it or been reckless in respect of it, then you're not going to come you're not going to fall foul of the Wage Theft Act. But the Fair Work Act doesn't care whether a underpayment was as a result of an honest mistake or not. That it is an offence to pay someone less than the minimum wage as set out in a modern award, an enterprise agreement, or the federal minimum award, failing to pay entitlements to annual leave, personal leave, and the rest of it are also offences. And those offences are created, whether it was done by honest mistake or not. Obviously, when a court comes to consider those kinds of offences, they will be much more sympathetic to an honest mistake than a deliberate one. But the point needs to be borne in mind that even an honest mistake is an offence under the Fair Work Act. But yeah, clearly there's a lot of overlap between the two bits of legislation, and paying employees properly is something which is important for all employers, because of the risks that they face of getting it wrong. I think the other thing, this is just sort of stepping back a bit, but I was going to say it earlier, but I didn't mention it. But Aahana, when you talked about the Wage Theft Act applying to not just modern award payments, entitlements under the Fair Work Act, but also to entitlements under contracts, it seemed to me that was a big deal, because most of this kind of legislation, we think about protecting vulnerable employees, sort of the lower paid employees in the community. But if it also protects underpayments under contracts, are we going to see sort of the Wage Theft Act being brought into play, where there's a senior employee disputing a payment, an underpayment under a bonus condition or an incentive condition in their contract? I guess we could be. So we'll have to watch that space. But okay. So shall we? We're kind of over halfway through. So should we talk a bit about some sort of practical tips for employers who are worried about paying employees correctly?
Sure, thanks, Simon. So I guess the key thing now is, what can you do to safeguard your business from a potential claim under the new Act? I guess our key tips would be that, you should ensure employees are being paid appropriately with reference to the applicable award or an enterprise agreement, and obviously any entitlements under a contract of employment. In terms of making sure that you're paying someone with reference to a modern award, it is important that you check this every year, especially if you're paying an annual salary. You should ensure that salary is high enough to compensate the employee for example, if they worked overtime hours during the year. And even their roles and positions are regularly reviewed to ensure, and checking their duties, just to ensure that they're appropriately classified under an award, such that, maybe a salary increase might be required. So it's important that you check that on a regular basis. Of course, it's also important that accurate employee records are being kept and maintained in accordance with the Fair Work regulations, and in particular, time and hour records. So you should make sure, say, for example, you have a business where you roster employees, but it's, you know, it's quite often that they'll end up working different hours. You should have proper time and wage records and timesheets for employees. The other thing, I guess, even any employees who are sort of in senior management, you should review their salaries on an annual basis, because it might be that they'd still be covered by a modern award. And again, like we've mentioned a few times, there might be additional obligations under their contract because they're senior level, and just ensure that you're paying them any additional obligations that arise under the contract. The other, I guess, important thing is ensure that the corporate culture within the company is not one where these sorts of things are tolerated. You know, if you're aware that if you're working within a larger organization and you're aware that a certain manager, you know, say for example, deducts wages or doesn't pay someone for working overtime, that sort of stuff should be reviewed. You shouldn't have a culture within the organization where any of this sort of stuff is encouraged or tolerated, because, you know, it can ultimately be in breach of the provisions of the Wage Theft Act. And another important thing, which I think it's quite important, is any sort of senior staff, such as HR managers, anyone in payroll, anyone in accounts, any employee with oversight on how an employee is paid, they're provided with adequate training in relation to compliance with any applicable workplace laws. So those are our key tips, unless you have anything to add, Simon.
Yeah, I mean, I suppose it's there is so much kind of regulation and law in Australia, particularly in the modern award system. As you say, employers have to get that sort of stuff right, but it can be quite difficult. You know, there's 150 different modern awards. It can be hard to know which award applies to your staff as a kind of starting point. And, you know, within each award, there are generally kind of, you know, different levels of pay depending on experience and qualifications. There'll be different rates of pay depending on whether they're working in the morning or in the evening, you know, different rates for weekends, overtime rates, you know, and then sort of allowances for all kinds of different things, you know, uniform allowance in certain industries, you know, allowances to dealing with kind of working at height or working in wet conditions, you know, you name it, anything, and you could imagine of. So I think, you know, it is a challenge for employers to get that sort of right. So I'd always kind of recommend people to get some professional help unless you're kind of completely confident that you've got the award coverage for your business correct. So yeah, I mean, that would be my other top tip. There's advice, you know, there's advice and resources out there to help you, and certainly, you know, as I mentioned earlier, that kind of due diligence defense to the Wage Theft Act. You know, you're going to be able to kind of rely on that sort of thing if you've sought some professional advice and you've relied on it. So you know, we hear it every day, and we understand how difficult some of this sort of stuff is, the requirements for exactly how an employee is paid, but there is help out there, so kind of do avail yourself of that if you need to. But yeah, no, I think those are some really good tips. The other thing which we get involved in a lot at EI Legal at the moment is doing kind of audits of rates paid to employees. So you know, if you are concerned or you just want to, you know, double check that everyone is being paid correctly, there are kind of options for you know, lawyers or other organisations to audit your pay. You know, perhaps take a few kind of random pay periods, a few employees at different levels. They can go through what they're paid compared to the hours they've worked, and you can get some assurance that you're doing things right. So yeah, I would encourage people to get some professional advice if they are concerned about these issues. Yeah, I think that's all I was going to say on that. Should we look? We've got 20 minutes left, so we've got a fair amount of time to go through some questions. Should we go through a few that came in early on with people registering for the webinar? So maybe we can go through a few of those and then see how many people have asked while we've been talking.
Okay, so one of the questions that has come through, Simon, is if a person is on a salary and there's an expectation that you work unpaid overtime because you're paid above an award, how much overtime is too much? And when does unpaid overtime become wage theft?
Yeah, thanks. Thanks, Aahana. So yeah, it's a really interesting question. I guess it's kind of two concepts to think about in terms of employees working unpaid overtime. You know, it is perfectly possible to arrange your affairs as a business so that you pay an employee a salary, and that is designed to cover all the hours they work. So you know, you pay a salary. Part of that salary, there's an expectation that an employee does extra hours here and there, or even you know, every week, and that salary covers those hours of work, and in a sense that overtime is unpaid. You know, that arrangement is fine, but the important thing with that is to make sure that the salary is sufficient to cover all the hours of work. So if they're an award employee, you'll need to look at the number of hours that they work, the number of overtime hours. So generally overtime is paid over 38 hours per week, and some awards have provisions about overtime after a certain number of hours performed each day. You'll need to work out if the employee was paid at the minimum rate for each hour they worked. What does that equate to? And you know, you need to work out that the salary is sufficient. A lot of awards now have annualized salary provisions, which have some kind of quite strict rules about paying an annual salary and the sort of information you have to give to employees when you pay an annual salary. So you need to kind of check what the award says. So that's the first thing. Make sure that the salary is sufficient. The second thing is there is also obligations under the Fair Work Act that an employee can only be required to work reasonable additional hours over 38 hours per week. So, and the Fair Work Act lists a range of things which need to be considered when you're assessing whether the requirement to work additional hours is reasonable. So even if the salary is sufficient to cover the hours worked, so we're not in kind of wage theft territory or underpayment territory, there is still this obligation that an employee can only be required to work reasonable additional hours over 38 hours per week. And what is reasonable is going to depend on the particular situation, but some of the factors that you would need to consider are, you know, the effect on the employee's sort of health and well-being, whether they have any caring responsibilities or personal reasons why they can't work those additional hours, you know, the seniority of the position. The more senior they are, the more reasonable it is for employees to be required to work those longer hours. how much notice they're given of the requirement to work additional hours, all of those sorts of things. A question came in while I was talking about whether this is relevant to award-free employees as well. The answer is yes. The main difference, I suppose, between award-covered employees and award-free employees is award-free employees are just entitled to the federal minimum wage, which is a set amount per hour, which, you know off the top of your head what it is, Aahana? $19.76, is it? Something around that. It just went up on the 1st of July. But an award-free employee is entitled to just that hourly rate of pay, regardless of how many hours that they work. So if they're working 50 hours, they just get 50 times that rate. Whereas an award-covered employee, you know, there's all these provisions about overtime and the like.
It's $19.84.
There we go, $19.84 cents. So that's the main difference between award-free and award employees. There's no entitlements overtime rates for an award-free employee, but the rules about maximum hours still apply. An award-free employee can only be required to work more than 38 hours a week if that requirement is reasonable.
Thanks, Simon. And I guess just to answer that very last part of the question, when does unpaid overtime become wage theft? It'll become wage theft where I guess those additional hours are not compensating the employee. The salary is not enough to compensate the employees for those additional overtime hours. You know that as an employee, you know it's probably not compensating them. You either turn a blind eye, so you're reckless to it, or you're just not doing anything about it, and it's dishonest. So that's when it could actually be an offence under the Wage Theft Act, which is why it's also important to, when you are paying an annual salary, to do an annual reconciliation, especially when you're aware that the employee is working significant additional overtime hours. So I guess I'll jump to the next question, Simon, that came through before the webinar. If an underpayment has occurred and poor record keeping means that each employee's entitlement cannot be determined with 100% accuracy, can employers utilize a formulated approach to calculate back pay for all affected employees?
Yeah, thanks, Aahana. So I guess the first thing to say about that question, if an employer hasn't kept records of hours worked and how much an employee has been paid, that is likely to be an offence under the Fair Work Act, and if this was done sort of dishonestly or recklessly, also under the Wage Theft Act. So the first thing to point out is failure to keep records is an offence under both the federal and the state legislation. But yeah, if you're in that situation and you're trying to put things right, you're trying to calculate a back pay to an employee or employees, yeah, like you're just going to need to base it on a rational, reasonable basis, whether that's kind of an estimate of the hours that the employee worked or whatever. Yeah, that's generally how it's done. So yeah, I think that would be the correct approach.
Thanks, Simon. And the next one is, we were actually talking about this one before, but all of our employees are on common law contracts, as there is no modern award that applies. What are some of the instruments we can use regarding sort of reasonable overtime practices and compensation?
Yeah, thanks, Aahana. I guess this question is asking if, as we say, there's no entitlement to overtime for an award-free employee. If you want to compensate them for working at additional hours, how do you do that? What's a fair process? And I suppose, look, because the law doesn't require overtime payments for such employees, it is up to you how you pay them for such work, so long as they're getting paid the minimum wage for such hours. But I guess a reasonable approach would be to mirror the approach taken by modern awards, which is hours over 38 hours per week are considered overtime, and generally an employee will be paid time and a half for the first couple of hours, maybe 2 or 3 hours at a time and a half, and then double time. It varies from award to award, but if you were going to go for an approach that kind of mimicked what's in award, I would say do that.
Thanks, Simon. And the final question that I have here is, what counts as dishonesty? If a company or individual declares that there has been an underpayment, are the consequences less severe? I guess to answer that one, we've gone through what dishonesty is. But if a company or an individual, they recognize that there's an underpayment and they take steps to rectify the underpayment, and they, pay back by, for example, paying back the employee, then it's less likely that it will be considered dishonest under the Wage Theft Act. You may still face consequences if the employee, say, for example, has brought underpayment of wages proceedings under the Fair Work Act, and you realise there's an underpayment and you pay back that underpayment, you may still be faced with a penalty under the Fair Work Act. The court might still impose it, but it's likely that the court would impose a significantly less penalty if you've sort of identified there's an underpayment and you've taken corrective action.
Yeah, I completely agree. I mean, when we're talking about penalties, be it the 10 years imprisonment or the $990,000 penalty under the Wage Theft Act, or those penalties that I was talking about under the Fair Work Act, those are maximums, and clearly I would think, if you come forward and you put your hand up and you say, look, we realise there's been an issue and we want to put it right, that those are kinds of that sort of remorse and willingness to put matters right. That's really, I think, going to be very persuasive to a court, that any penalty should be at the minimal level. And you see it a lot in the Fair Work Ombudsman, businesses kind of self-reporting. A lot of big businesses do audits, realise that there's an issue and then come forward to the Ombudsman and say, look, we realise we've made a mistake, we're going to put it right. And then, usually they come to some agreement that they pay like sort of a contrition payment, but it's at the lower end of the scale. So I think, if you know that there's a problem, the worst thing you can do is kind of sweep it under the carpet. You need to get some advice, and the consequences are always going to be less severe if you put your hand up. Okay, so shall we, I think that's all the questions that came in before the webinar. Should we look at some of the ones which have come in while we've been chatting? We've still got about 7 minutes.
I can read you the first one, Simon.
All right.
So the first one is, employers that breach the legislation, will they face penalties from both the state and federal government? I guess we've sort of touched on this, but the Wage Inspectorate who's been appointed under the Wage Theft Act, if they have the powers to bring proceedings where they find that there's been an offence under the Act, and they themselves sort of might bring proceedings, and that might result in penalties under that Act. Separately, if there's been an underpayment to an employee, the employee might also bring proceedings in the federal courts, which might lead to separate penalties. So yes, I guess in a nutshell, it is possible, but we haven't seen that in operation yet. That's, I guess, yet to happen.
Yeah, thanks, Aahana. I'll look at some other questions. There's one here that there's a lot of discussion around employees who are paid hourly and tend to fill in timesheets. What about employees who are paid a salary? will there now be a mandate to make sure times are tracked via a timesheet to ensure they are not underpaid for a year? Senior staff are not used to filling out timesheets. This is a really interesting issue which has kind of come up a lot recently. I guess the answer to that is to a degree is impacted by whether the employee is covered by a modern award or not. If an employee is covered by a modern award and they're working a pattern of work, which means that they're required to work overtime. So, for example, if they're working over 38 hours a week, but they're paid a salary to compensate them for all the hours worked, there's a requirement under the Fair Work regulations that any employee who's entitled to overtime, regardless of whether that is wrapped up in a salary or not, if they're entitled to overtime under an award, then an employer has an obligation to record the number of hours of overtime that they're working. Now, a lot of employers don't do that, and it's not a widely understood obligation under the Fair Work regulations, but that obligation is there. So, whether you do that through time sheeting or some other method, there is an obligation to record the number of hours that an employee is working, the number of overtime hours they're working. So that obligation is there. I guess the other point to say is, unless you have a good understanding of the number of hours your employees are working, you're always going to be at the risk of there being an underpayment, particularly when we're talking about salaried staff, and unless they're really being paid significantly above the award or they're real high earners, then you're always going to run the risk that down the track someone comes back to you and says, look, I've been doing 50, 60 hours a week. My salary wasn't sufficient. You need to pay me, and without having a record of the hours that they've been doing, then it's going to be very difficult to kind of refute that sort of claim. So I guess there's one kind of practical tip is think about how you can record those hours, and the other practical tip is have some policies and procedures, have a culture which deals with employees working excess hours. Do you need to have a written authorization from your manager in order to work additional hours or hours over a certain number a week? Have a system in place, or think about implementing a system where the number of hours that employees are working, and if they need to work additional hours, but they need to seek permission. That would be my advice there. I know that's hard, and I know that sort of sounds perhaps impractical, particularly for the most senior employees, but it will tend to be the employees who are kind of at a lower level, who aren't getting the kind of big bucks, but that this is going to be an issue for. So I think that does require some careful consideration. Probably got time for one more, Aahana.
There's been a couple of questions about whether sorry, I think I was on mute, so I'll repeat myself. There's a couple of questions about whether an outsourced sort of payroll provider can be liable under the Wage Theft Act, where they're assisting a client with processing sort of a payment where there's obviously been some sort of deduction, or they've been asked to withhold something. I guess under the Wage Theft Act, there's two different considerations. Under the Fair Work Act, there's provisions to do with accessorial liability, where if someone is knowingly involved in a contravention, they can be held liable, and there's separate penalties for an individual who's knowingly involved in underpaying someone. And there is some case law where an accountant has been held liable. But again, it's quite a sort of a high bar. You have to be knowingly involved. You need to know that what you're doing is wrong, and you sort of don't give the correct advice, or you still go ahead and do it. In terms of the Wage Theft Act, I guess we haven't seen it yet. Any thoughts, Simon? I see you going through the bill.
Yeah, I'm scrambling through it to find the answer to that question. And yeah, look, I don't have it at my fingertips. But yeah, as Aahana says, it is certainly an offence under the Fair Work Act for a payroll provider, for example, to knowingly be involved in underpaying someone. Whether that extends to the Wage Theft Act or not, it might be a bit early for us to say, but yeah.
I think it might also come down to whether that person, like an outsourced payroll provider, is not necessarily going to be an officer, because only the corporation that is the employer and an officer can be held liable under this act, which is what we can see today. I mean, there hasn't been any proceedings, but that's what the act states. And a payroll provider is not going to come within that definition. But say, for example, you have an internal payroll officer who's quite senior within the organisation, and they have the power to make decisions on behalf of the organisation, then potentially that individual person could be held liable under this act.
Yeah, thanks, Aahana. Okay, so look, we've just gone past 3 o'clock, so I think we'll need to wrap things up here. Thank you, everyone, for your attention and your company today, and thank you for all the questions that have come in. I know Employment Hero will have a look at those, and I'm sure we'll pick out some kind of general themes, and they might well, do some blogs or content about trying to address some of those common questions. I'm sure. Look, if you do need assistance with any employment issue or anything you've heard about today, do reach out to Aahana or myself. We're available via our email address, info@eilegal.com.au. We have a website and a blog that you can subscribe to if you're interested. That's over at eilegal.com.au, the website. We also have a podcast that we've recently launched, which you can also subscribe to via our website and the usual podcast channels. There's a link to that on our website, and Julia might have posted a link to that too. So I hope you found today useful. Do sing out if we can be of any assistance. Thanks, Aahana, for jumping in at the last minute.
Thanks, everyone. Thanks for listening in.
Yeah, thanks, everyone, and we'll speak to you soon.